Today we're going to talk about securities law and corporate governance. So this is in line with the other corporation topics we covered before. And so the primary focus of securities law has been to provide investors with optimal disclosure in the interest of having transparency, to protect investors from overreaching by corporate managers, that is, their agents. Traditional functions of the Securities and Exchange Commission, the SEC, oversees filings and disclosures required by the federal securities law. So the federal securities laws requires them to reveal their financial situation. So they have to have themselves audited by accountants, professional accountants, who are licensed by the SEC to do this. And that way investors can be assured that as far as the auditors are concerned, can tell that this firm is financially sound. So that's the purpose of that. And they'll have all the information they need to assess whether or not they want to invest in it. Okay, now that's maybe a primary focus is to have these filings that it discloses nowadays on its website. It also polices security exchanges and markets. So the Wall Street Exchange, the American Exchange, both of them are going to be managed by, are going to be overseen by the SEC. It investigates suspected securities fraud. So if they are alerted or they discover that there is some illegal activity going on, maybe by some security firm, some brokerage firm, they'll investigate it and bring them to justice. It regulates brokers, dealers, and investment advisors. It supervises mutual fund activity. So mutual funds also come under their jurisdiction. It brings civil cases. It doesn't always bring a civil case, but it will bring civil cases against people who are violating the securities law, and some of them are. Though it cannot bring, obviously, it cannot bring criminal charges, cannot bring a criminal case, because that's the job of the Department of Justice. So like other agencies, they're only able to bring civil cases because they don't have criminal authority, because they're considered part of the legislative body. Anyway, they also refer suspected criminal conduct to the DOJ. Okay. Amended powers. They seek civil sanctions for violations of foreign securities laws, so the Foreign Corrupt Practices Act. So we have the Foreign Corrupt Practices Act, which is supposed to prevent us from engaging in disgraceful behavior overseas. They have the power to suspend trading if volatility becomes too great. Volatility, of course, is trading. If there's too much trading, too many people are selling, too many people are buying. If the market's fluctuating a lot and going off on extremes, they can shut it down. And so that might prevent the market from crashing, at least for that day anyway. Power to suspend trading if volatility increases. Power to grant exemptions from securities laws. So there are some firms that are exempt, some situations where there are exemptions to be granted for certain kinds of trading. We'll talk about those later. Where circumstances justify it, to demand additional corporate disclosures, so they can demand that the corporation make further disclosures. Securities Act of 1933. So basically before 1933 there were only state corporation laws. And so the Securities Act was part of the New Deal. And if you remember, 1929 was the day, it was the year that the market crashed in New York, and there were lots of firms that had been mismanaged and a lot of corruption, and so there was prosecutions and all kinds of things. And anyway, one of the first things that FDR did was to pass the Securities Act. It requires the disclosure to the public of all essential material information likely to affect a stock's value. So that's all financial information that would maybe be material. Material, of course, means it will have an impact. So something is material if it's going to maybe change people's decisions. If you knew that Enron was actually losing as much money as it had, you would not have been holding on to its stock. You would not have been buying its stocks. Nobody would have been buying its stock if they knew the truth. So sometimes the system breaks down if people do the wrong thing. In this case, you had more than one person doing the wrong thing. You had the managers and accountants at Enron misreporting their income, and then you had auditors who weren't doing their job and catching that, and they should have caught it. And the financial reporters, oftentimes, we like to think of the press and the media as being some sort of a check on corruption, but sometimes they're not. Sometimes they don't do the job either, so they weren't doing it either. Upon the issuance of and sale of new stock, the issuer must file a registration statement with the SEC. This is under 1933 Act, and provide investors with a prospectus prior. So a prospectus is when you're first offering a stock, people don't know how the stock's going to perform, and so you would put in there the information. If it's been an ongoing company, and usually it is, this company that's maybe been privately held and it's going public. If that's the case, you can present them the information of what kind of success it had as a private corporation, which you would think you wouldn't bring it to the public unless you had some success otherwise. And the bank would have to underwrite it before it goes in. So the issuer must file a registration statement with the SEC and provide investors with a prospectus. Prospectus is that information that you need to know about the firm, what its plans are, what its products, what kind of financing it has, how much capital does it have, how much loans, what is its financial structure. All that is in the prospectus, and what are its plans for the future even. Prior to the sale of the security, these investors have to get this prospectus. And in order to assist investors in their evaluation of the offer, obviously. Okay, definition of a security. A transaction in which the buyer acquires an investment in a common enterprise. That is a typical business, right? So a common enterprise is one that's available to all to buy, and is maybe serving the public in general. Reasonable expectations of profits. So, so there has to be a reasonable expectation of profits for people who buy the security. Otherwise, nobody would buy it. So, as part of the definition of what a security is, that it's reasonable for you to think that it will maybe become more valuable. That's assuming, of course, that the firm does what it says it can do and is successful. Reasonable expectation of profits. Gains or losses derived from the efforts of professional management. So you want to sell stocks, you're going to need to have some professional management. People want to make sure they're buying from people who know what they're doing, right? Contents of the registration statement. It has a description of the security, tells you what kind of security it is, whether it's common stock, whether it's preferred stock, whether it's a bond. Is it a preferred bond? Is it a mortgage bond? Is it subordinated or unsubordinate? So it'll tell you that kind of information about what kind of so you have to have a description of the security on the face. Properties owned and the nature of the business. So it has to say what kind of assets it has and what kind of business they're doing. Are they doing trucking business? Are they doing manufacturing business? If so, what are they manufacturing? Appliances or cars or furniture? What are they manufacturing? Or are they a conglomerate? They need to tell you all that. Description of management. Description of stock holdings. Some corporations will have their own stock holdings. They'll be owning other corporations. Some of them are holding companies, so they hold other corporations. Its remunerations, that is, what kind of money does it make, and other benefits. What kind of benefits can you expect holding the stock? Interest of the directors in any material transaction with the corporation. Okay, so are there any conflicts of interest? And then you need a CPA certified financial statement, so that's the audited statement. And CPAs are basically signing that, saying that they're guaranteeing that it is financially sound. And of course, they could be liable for negligence if they don't do their job right, so they have to do that. And so it becomes a basis upon suing them if in fact they should have known that this corporation was not being run right, that it was cooking its books. They should have caught that. So they are, you know, on the line. This is what they do, and this is part of the risk of their business. Description of pending lawsuits, if any. So if there's a lawsuit, you would like to know it before you invest in a business, whether or not they're being sued. Waiting periods. No sales prior to filing and receipt of prospectus. No sales within 20 days of the filings. During the waiting period, there's limited printed and written advertisement is allowed. So you're allowed to do tombstones ads, they call them. And so these are ads, you'll see them in the Wall Street Journal, telling you that they're going to be issuing a stock, and some of the basic terms are there. And of course, it's more fully laid out in a prospectus. After the waiting period, tombstone ads are permitted. Other ads can only be made if a prospectus is delivered with them. Exempt securities. So there are some kinds of securities that are exempt. So small offerings under Regulation A, where there's $5 million within 12 months is what they're selling. That's very common. So this is one that doesn't have to abide by the SEC rules so much, so they're exempt. Commercial paper maturing within 9 months, so it's not covered by the SEC. Commercial paper, that's, you know, promissory notes and that kind of thing. So securities of charitable organizations, they're not covered by the SEC and its laws. Securities from reorganizations issued in exchange for reorganizations of bankruptcy, corporate bankruptcies, in exchange for issues existing securities and certificates. Stock splits. These where a corporation offers as a dividend to give you shares. So if you had 50 shares, they give you another 50. Now you got 100 shares. Your value, your ownership value is no greater than it was before. But for some reason, this seems to have some impact on people buying shares. So if you're trying to sell, if you want to see some activity in a stock and people bidding up the stock, you can try a stock split. Like I said, then everybody will get an additional bunch of shares, and it's just simply diluting what each share is worth. Then, right? So securities to finance railroad equipment or insurance and annuity contracts which are regulated by state law, and government issued securities are not going to be covered by the SEC rules. This securities issued by financial institutions, for example, certificates of deposits. Exempt transactions are small offers under Regulation D, and so these are where there's not a whole lot of stock being sold. Small offers to accredited investors only, so you can have stock that you sell only to accredited investors. Accredited investors are people who have substantial enough wealth, maybe it's a couple million now, that the SEC doesn't feel that they have to be protected, that they can protect themselves. So they're accredited investors, and that's determined by how much money they already have. Intrastate issues. No resale can be made to non-resident investors within 9 months. Certain resales which qualify under safe harbor provisions. Violations of the 33 Act. Any party signing a registration statement which contains a material false statement or omission is liable. So if you knew there was a material false statement, you wouldn't want to sign that, because there are penalties. Fines of up to $10,000. And imprisonment of up to 5 years, depending upon what your intention was, what kind of criminal activity you were engaged in. Is it a felony? You might get 5 years. And so that also goes to the statute, and it defines certain actions as felonies and others are maybe misdemeanors. Injunctions against selling securities orders to refund profit. So these are all violations. Civil damages if a private action is filed. And so that's that. Defenses, a violation of 33 Act. Denial of allegation, of course, it's always a defense, right? You deny the other party's charges, what they're alleging that you did, stating there was no material misrepresentations or omissions would be, a denial. If the assertion was there was a material misrepresentation. Denial of materiality, that the untrue statement or omission was immaterial, meaning it really wouldn't have affected anybody's decision, so it might be just a small amount that is wrong. And maybe some sort of typo error or some, not a major error, not a systemic error, just some little thing that doesn't really amount to anything that would have changed anybody's mind about whether to buy or sell stock. Due diligence, reasonable grounds to believe the statement is true and complete after reasonably investigating the statement. So firms will hire other firms, firms who are offering stock will have their stock and have their offering examined by people who examine their financial situation and the offer of stock, and it's called due diligence. These firms do due diligence, so they check it out. This is before it's offered, so it's not an audit by accountants, but by a firm that specializes in doing this kind of work. No reliance. Plaintiff bought the stock knowing of the misrepresentation or omission, so he knew there was something wrong, and he bought it anyway. Securities and Exchange Act of 34 regulates markets and exchanges. So we had an act in 33 and an act in 34. The act in 33 went to the actual firms and what they were doing and what they're required to report. The 34 Act goes to the exchanges. Security exchanges and markets and exchanges where securities are traded, so that's what it regulates. Established the SEC. So the 34 Act is actually the one that established the SEC, which is the administrative agency we're concerned with here. Prohibits fraudulent insider trading. We'll talk about insider trading in a bit. Defines criminal violations, so it says certain things are criminal violations, and we'll talk a little bit about that. And provides for civil sanctions, that can be meted out by the SEC itself. The SEC can do civil sanctions, it just can't do criminal sanctions. Class action lawsuits. So shareholders also can bring a securities civil class action suit. They can bring any kind of lawsuit that they can make grounds for. But class action is one thing that you might do. So for instance, if it's something that's going to affect all the investors, you can have all the investors joined and and getting maybe whatever they should be getting in view of the violation. So class action lawsuits can be brought by shareholders if they can prove violation of the prohibition on fraudulent insider securities law by corporate insiders and/or negligence in auditing. They can win those lawsuits. Rule 10b-5 or Section 18 deal with insider trading. Fair disclosure. The SEC regulations, FD, requires that if a company intentionally discloses material non-public information to one person, it must simultaneously disclose that information to the public at large. So it can't just choose to tell somebody information that should be of interest to the investing public. It must do so simultaneously. So in the case of unintentional disclosure of material non-public information to one person, the company must make a public disclosure promptly. So mistakes might happen, but if there was a disclosure, maybe it's unintentional, but you need to alert the general public about it. Statutory civil fraud, insider trading. So here I list the names of the rules. So what we're talking about is Rule 10b-5, which is the rule on insider trading, and Section 10b of the Securities Act. That's based on. So that's the actual law passed by Congress. The Rule 10b-5 is a rule passed by the administrative agency, the SEC, and it specifies what penalties there are. So Congress will set up agencies like this, and they'll specify something as being illegal, but what you need to prove that it's illegal is going to be specified usually by the agency itself. And so, in this case, the elements of insider trading or statutory civil fraud is there has to be a security transaction. There has to be a material misstatement or omission. There has to be scienter. Scienter is knowing, it'd be a knowing intent to defraud in this case. So it's knowing intention would establish scienter, a knowing intention to do something wrong. In this case, to commit fraud, to mislead people. And there has to be reliance. That is the victim, the person who you're defrauding, relied upon a statement that was false, you know, and so that's what reliance would be in this case. Okay, so and actual dollars have to be lost by investors, so these are not theoretical suits. Not going to waste our court's time with that, are we? Insider trading, the trading of a public company stock. So this is just a general definition of insider trading. We just gave you the elements to establishing insider trading, but what is the definition of it? Well, the trading of public company stock or other securities such as bonds or stock options. So stock options would be included. This is maybe a right to buy a stock at a later time, or a right to sell a stock, an option or a put, so-called, based on material non-public information about the company. So, so a person who's an insider trades in the securities of the firm based on information that's material and non-public, and it's about the company. Usually it's something that is going to make the company more profitable in the future or make it less profitable, maybe even endanger it. It might be a lawsuit. It might be they discovered a gold mine, something like that. So there are cases like that. Trading by insiders is legal as long as it does not rely on undisclosed material information. Not available, that information would be not available to the public. So that's undisclosed information, right? So it's not available to, that's why it's undisclosed. That's why I call it undisclosed. So what's wrong with that? Well, if you're an insider and you know there's something, that there's a gold mine, then you know that the stock's going to go up. And so you're able to buy people's stock, and they're not going to get the benefit of that stock. They're not going to even get the benefit of knowing that it's going up. They don't know it's going up. You can then make a profit by basically taking away from them a profit they would have had if they'd simply held on to their stock. And so that makes it material, and it makes it wrong. Okay, based on material, non-public information about the company. Trading by insiders is legal as long as it does not rely on undisclosed material information. And that information would then not be available to the public. Corporate insiders. Who is a corporate insider? Anyone possessing undisclosed material information concerning securities who buys or sells the security can be prosecuted as an insider. Violators can be officers and directors and other employees and their tippees, so anybody they tell, or anybody who overhears them. So if you got a chauffeur and you're a stock trader and you're driving in your car and you're talking to people on your cell phone, and your chauffeur overhears what you're talking about, and he gets the idea that it would be a good idea to buy X, Y, Z, and he buys it, he is actually engaged in insider trading. And he's a tippee. He got a tip, even though you didn't mean to give him a tip, but he got the tip anyway. And so all these people would be insiders. So anybody you tell it to intentionally, unintentionally, accidentally, is an insider if they trade on this. Okay, and so they can't trade without that information first being publicly disclosed. Persons working for or with the firm who acquire inside information, for example, lawyers. Lawyers oftentimes are working on the issuance of these. There are documents that have to be looked over. There are legal issues that have to be discussed. And so lawyers are familiar with maybe what the company is going to offer in secrets of the firm that are maybe not out there yet. Also, printers sometimes would have that. So anybody who knows the information is an insider. you know, so this is called, this latter, the lawyers and the printers knowing, it's called the misappropriation theory. They get the information for one reason, but they're using it for their own benefit, and that's a misappropriation. And who are they robbing from? They're robbing from the other public investors who, like I said, either are not going to sell or going to sell their shares to the insider. So SEC versus Texas Gulf Software Company announced a level playing field theory of insider trading in this case. Why do we have insider trading? So that the investors are all on an equal footing in regard to buying and selling shares. So nobody has an advantage, an unfair advantage. That's why we have it. So it's called the level playing field. The court held anyone with inside information must either disclose the information or delay trading until the information is made public. Officers of the company had inside information about the discovery of a gold mine, and they profited by buying shares and call options on the company stock. That's an insider trading example. Sharon Watkins knew that Enron might implode. She wrote the letter on that. Okay, for her to then sell that without it first becoming public information would have been an act of insider trading, would have been an illegal violation of Rule 10b-5, and she did that, but they didn't prosecute her because they have discretion to decide whether to prosecute somebody or not, which is a good thing, because they saw her as not being part of the problem. In other situations, they might have prosecuted her, but they saw her as being useful for bringing it to the public. Okay, now I'm going to tell you about another case, Dirks versus SEC, 1983. Dirk was an analyst. He would analyze stocks in the insurance field, and he had been looking into a stock because a lot of his clients were asking about equity funding. And he was told by telephone one night, after he'd left the company, Equity Funding, he was told by one of the former high-level executive officers that the stock was vastly overrated, overvalued, and that the company had intentionally been doing this. They were having parties where they would make up insurance sales that they didn't have. They'd fill out forms and then they'd resell them in the reinsurance market. Anyway, so it was a big scam going on at this thing, and he knew about it, and yet he had investors, institutional investors, pension funds and such as that, who wanted to invest in this particular insurance and equity funding, and he could tell them, well, no, don't buy it. But if he discloses who it is, why, if he discloses that he knows this information, which would obviously have a great impact on them, that would be a violation of the law. So, basically, there was a guy named Sechrest. He added that Sechrest was the guy who told him that it was overrated, overstated. Sechrest added that myriad regulators had failed to act on similar charges made by other employees. So other employees had already told the SEC, and newspapers, the Wall Street Journal had been told, and they just refused to believe it. They couldn't believe that this could be happening. And he informed his clients who sold the shares. So he told his clients, didn't tell them as much as he knew, but he told them enough that they charged him with aiding and abetting insider trading. So he wasn't buying the stock, so he wasn't trading in the stock, so he wasn't himself doing insider trading, but he was aiding and abetting others who were doing the insider trading by telling them the information that was the inside information. And again, now in this case, he had actually tried very hard to get the firm investigated by the SEC and by the Wall Street Journal and other newspapers, but nobody was paying any attention to him. And he had these clients, and he felt an obligation to tell them, because it's not good for pension funds to be losing their money in a situation like that. And so, so you're kind of caught in a terrible dilemma if you're in that situation. If you don't tell these people, they may lose money, and they'll be looking at you and say, well, why didn't you tell us? Don't you have an obligation to tell us? And if you tell them, you're going to be violating the law. So anyway, the prosecutors actually did bring these charges, and it got appealed up to the Supreme Court, and the Supreme Court dismissed it, saying that he basically was not part of the problem. Same thing has happened with Sharon Watkins, although not exactly, because she wasn't even charged. So actually, he would have had to defend himself, go out and hire a lawyer. And so that's something that the SEC should not have done. This is one of the reasons you give, or the DOJ should not have done, shouldn't have filed those charges. This is the reason you give these people discretion to bring this lawsuit or not. So that's the Dirks case. And now we're going to talk about the Martha Stewart case. Most people believe that Martha Stewart was convicted for insider trading. That wasn't so. She was being investigated for insider trading, and when she was being investigated, she lied to the investigators. So she was put on trial and tried and convicted of obstruction of justice, making false statements, and conspiracy for lying to investigators. So that was very silly of her, wasn't it? You see, in some ways, something similar happened in terms of Enron, in that they destroyed evidence. You can't destroy evidence. And so, you know, you need to be forthcoming when these police, whether they're investigators from the SEC, which are not, I guess you might say they're technically not police, they're not going to arrest you, but they may bring charges against you for civil actions, and you might have to pay a fine. And so Martha Stewart case, she was convicted, but not for insider trading, and I think she spent like 5 months in jail for that. And she should have known better, because she had actually been in the securities industry. She did have information, I think, but I'm not quite sure why they decided she wasn't engaging in insider trading. Maybe it was completely innocent somehow. Legalizing insider trading. Let's talk, there's another case I'd like to talk about, the Winans case. Winan was a man who wrote a column for the Wall Street Journal called Heard on the Market. And so these were rumors that were going around on Wall Street, okay? And he actually was receiving or giving, he was receiving information from companies that would be put into his column. But before he put them into it, once you put them into the column, it had been okay. What he was doing was he was giving that information to a broker who was then trading on his behalf, not in his name, and giving him the profits to that. So basically he's getting paid to give information to this broker ahead of time before he published the column. So that was insider trading, because before, this is information that was going to affect the stock price one way or the other. And so he was giving this to somebody who could then make a profit on it, and he's making quite a bit of money on that. And they caught him. And so his name was Winans, and he was prosecuted for illegal trading. So remember I told you that lawyers and printers can be held liable. Same way with anybody who's got inside information. If they've been given inside information, that may be legitimate, actually. And insider trading actually is, if we were people who are insiders who trade are not committing any violation. It's when information that is not made public is disclosed and used to gain advantage in the market, that's the violation. So it's not the insider trading. Insiders are required under statute to disclose their stock purchases, and when they purchase their own shares in a stock that they're an insider for, they have to disclose that. And so you can actually go to the library and find books that will tell you what the insiders have been trading. You know, if you want to see whether there's insiders on a firm who, GE, let's say General Electric, if you want to see if the General Electric insiders are buying GE shares, you can do so. And there's nothing wrong with that. And if you trade on that basis, that's okay, because it's public information. Anybody can get that information. So once it's disclosed, it's not going to be a violation to trade on it. It's when it's undisclosed public information that you're gaining an advantage, and that's unfair. And then you don't have a level playing field, right? Okay, so legalizing insider trading. Economist Warren C. Gibson, and I think he's not the only one, writes, when, this is quote, when the dissemination of significant news about a company is blocked by insider trading restrictions, that company's shares are mispriced relative to where the price would be if the news were out. Now, I might agree with that. If the news is bad, the investors will buy at prices they would not have paid had they heard the news. So that's true of some investors would maybe do that. The movement of capital towards more productive uses is inhibited thereby. I don't know about that latter part. I don't know if there's something more to this than basically what's being said here by this particular economist. So I believe that you have to maintain the confidence in the market, and in order to do that, you have to have a level playing field. So, and that's the problem with insider trading. Not that, certainly our stock market has no trouble selling shares. And, this should give the incentive, the fact that they can't trade on inside information should give the incentive to the officers and directors of a firm to get that information out to the public as soon as possible. And nowadays it shouldn't be all that hard because you have the internet. So all you have to do is put it on the internet and make it available to everybody. Section 18, liability. The 34 Act imposes civil liability on accountants who make or cause to be made a filed statement that at the time and in light of the circumstances was false, or maybe it's not false, it's misleading, false and or misleading as to any material fact. So always you have to have material fact. So it has to make a difference to your decision to buy or sell. That's all that means. Short swing profits, this is 16B. Insiders are required to report their trades, we said that. And so you can find out what they did trade in. If an insider realizes a profit from the purchase or sale of corporation stock within the 6-month period, then all the realized short swing profit must be returned to the corporation. And so basically they're restricted to seeking long-term gains. Because there's sort of an implication, isn't there, that they're trading on some sort of information that other people don't have. Maybe something that none of the other directors have either. A suit must be filed by either a corporation or a shareholder filing a derivatives action. I think the idea here is that we don't want directors, we don't want officers making decisions that's going to affect the price of the firm because they've invested in the firm. So that's why we have them disclose their trading. Proxy solicitations, Rule 14A9. Whoever solicits proxies, so proxies are before you begin selling on the initial public offering, before you begin to sell the shares of a new corporation, you'll maybe have to have a vote of shareholders, and so if you're going to be issuing a new set of shares, there will be proxies. Whoever solicits proxies must accurately and fully disclose all the facts that are pertinent to the matter on which the shareholders are to vote. So, so they have to do that. So basically, the board of directors will issue proxies or ask for proxies to vote the shares of the shareholders, basically giving them control of the corporation. Of course, investors don't have to give it to them, but a lot of investors will. And then anybody can ask for proxies and ask to represent people, I guess, if you do it right. Remedies include enjoining the solicitor from voting the proxies and money damages. So that would be the remedy for somebody who abuses this. Criminal offenses. Under Section 807 of the Sarbanes-Oxley Act, and there were criminal offenses under the old acts, an offender may be imprisoned for up to 25 years for willful violations of the 34 Act. So, so basically, I think I mentioned earlier that Sarbanes-Oxley increased the fines and increased the number of years that you could be in prison. So for up to 25 years for willful violations of the 34 Act. Under Rule 10b-5, a violator may be fined up to $5 million and imprisoned up to 20 years. So for insider trading, that's Rule 10b-5, you can be imprisoned for up to 20 years, or you may have to pay $5 million, or your profits will have to be returned to the corporation, maybe, and maybe you'll have to give up your shares, and maybe you'll be banned from trading. There's various things they can do to you under Rule 10b-5. Where there was a coordinated effort to defraud investors, RICO charges can be brought with sentences imposed in regard to the nature and implementation of the conspiracy. So RICO, what is RICO? Well, RICO is the Racketeering, Influence, and Corruption Act. Under RICO, a person who has committed at least 2 acts of racketeering activity, and we're going to tell you what racketeering, how that's defined, drawn from a list of 35 crimes, 27 federal crimes, and 8 state crimes within a 10-year period, can be charged with racketeering if such acts are related in one of 4 specified ways to an enterprise. Those found guilty of racketeering can be fined up to $25,000 and sentenced up to 20 years in prison per racketeering count. So sometimes there are multiple counts, 20 counts maybe even. It could be a lot of counts, so that can add up. In addition, the racketeer must forfeit all ill-gotten gains and interest in any business gained through a pattern of racketeering activity. So here's the definition of racketeering. Racketeering is a criminal act or a criminal act in which the lawyer's crime It's a criminal act in which the crime is fraudulent use of an otherwise legitimate business or a way to earn illegal money, either frequently or repeatedly. So it's an example of that. It would be the Mafia Protection Scheme. You know what that is, right? The Mafia goes into a shop or a business and says, got a nice shop here. It'd be a shame if something happened. And he cracks his knuckles and smiles, and he winks at the goon who's beside him, who spreads out his coat, and you can see his guns. and you say, oh, well, I think I'm being threatened here. That's what you say to yourself. And that would be racketeering. So this RICO Act was originally meant for the Mafia, but it has been applied in these SEC cases. So I think it was first applied by Rudolph Giuliani. You ever heard of this lawyer? Yes, I think he was the first one to bring it when he was the Attorney General for the Southern District of New York, which brings a lot of cases. And so they have a very big staff of attorneys, and New York is very active in regulating the securities market. So they have an interest in Wall Street, and they want to keep it legit. Anyway, so he brought the first case against the Michael Milken, I think, of junk bond fame. Anyway, so that's what racketeering is, and you can bring these charges against people. Okay. Agency problem. Although both directors and officers owe a fiduciary duty to put the interests of the shareholders first, often they have not done so. So oftentimes people are running the corporation. So Milken, for instance, was running a group at a big brokerage firm, and that group was implicated by Ivan Boesky, who was caught insider trading and prosecuted, and he turned state's evidence. We usually do this to get a better deal from the prosecution. And so he wound up with only 3 years instead of maybe 10 or 20 years in prison. And that agreement required him to disclose who his sources were, who were the insiders who informed him. And they were mostly people who worked under Michael Milken. And so Michael Milken was prosecuted for running this racketeering thing. And this was something that was done frequently and repeatedly. so it fit the definition, and he just brought that case, and it's been used since then. The structure of corporate governance has often been alleged as the cause of the agency problem. Starbucks includes corporate governance reforms intended to correct the problem. SOX reform seeks to increase the agent accountability, imposing tighter internal controls under Section 404 of that act. Greater transparency and more meaningful disclosures for the investors are required, and the act requires the CEOs and the CFOs, the Chief Executive Officer and the Chief Financial Officer, to sign and make certain certifications of the SEC filing. The defense of the defendants in Enron, Skilling and the Chief Executive Officer, their defense was that they didn't know that there were misrepresentations being made, and they're not accountants, and so they try to say, well, it's not our responsibility because we're not accountants, and the accountants put that in there. We didn't know they were wrong, and we couldn't tell anything. We're just a bunch of gullible kids, or something. Anyway, so I think famously, Warren said that he wasn't fooled, but he was fooled. Okay. The effect of making them sign this statement is to make it difficult for these corporate agents to use what I call the Sergeant Schultz defense. I see nothing. So this is from the old Hogan Heroes TV show, in which a German sergeant refused to admit that he was seeing anything that the prisoners were doing in their plans to escape from the prison camp. Okay, and he would do that repeatedly in every show. He'd always wind up saying, I see nothing, because he didn't want the lieutenant, the commandant to penalize him. Okay, 906 certification. The CEO and CFO, again, certify that the financial statements filed with the SEC, that the statements fully comply with all of the SEC requirements. So this basically they're admitting that they are supervising these things. Okay, that's what they're supposed to be doing, right? They get paid big bucks to do this, and they should be able to do it. If they can't do it, they ought not to be taking those jobs. All the information in the reports fairly represents in all material aspects financial conditions and results of the operation of the issuer. So that's what the audit is supposed to establish, and so they have a real reason to make sure that that's the case, and to hire competent and honest accountants to do the audit, and accountants to prepare the books, and they need to do that. And they have this. And there's also 302 certifications for each quarterly and annual filing. The CEO and CFO certify that they have reviewed the report and it contains no untrue statements or omissions of material fact. So they need to read that. They should know what's going on in their firm, right? They're being paid, and they have the top supervisory role. If they establish an adequate internal controls that they have established, an adequate internal control system to verify all material information and definition, and that any deficiencies in the system were disclosed to the auditors. So, violations of Section 906, remember that was a certification requirement. The CEO and the CFO who knows a report or statement filed with the SEC does not meet all the requirements of Section 906 can be fined up to $1 million and or peanuts, really, because the amount of money that they were taking in Enron, that was peanuts, and or sentenced to 10 years in prison. Willful violators can be fined up to $5 million, well, then maybe that might have more teeth, and sentenced up to 20 years. Other governance SOX issued. 402, Section 402 prohibits loans to officers and directors. Exceptions are for houses and consumers loans. So there are some exceptions to that. So I mean, this was a way of compensating people, but it's not really thought to be. It's thought to be part of the problem with the directors and officers are supposed to be promoting the profitability of the firm for the investors. 806 provides protection to whistleblowers, so Section 806 provides that. All audit committee directors must be independent outside directors, okay? And so that's to help prevent fraud from going on. And the audit subcommittee hires, fires, and seeks compensation of the external auditor. 403 speeds up reporting deadlines for short swing profits under Rule 16b, and also there was a bit about audit committees must have a finance expert. So Warren Buffett would be a finance expert. The person who had run a computer audit for an accounting firm would maybe be a finance expert. It has to be somebody who understands how to read these things. Basically, all required. State security laws. A number of recent major cases have been brought by state authorities under so-called blue sky laws. And these are state laws, like New York has. Chiefly, these state laws require disclosures, prohibit security fraud. Okay, that's it for today. Thank you for everything, and I hope you enjoyed this as much as I did, and we'll see you.